Welcome once again to my channel. My name is Msimet Alex, and basically today I'm going to guide us through or to guide us about leases, creation of leases, termination of leases, uh, actually what amounts to leases, basic elements of a lease, essentials of a lease. Basically, that is what I'm going to take you through. Basically, this is foundations of land law and or what we usually call land law 2, and that is basically what we are going to look at this point in time. What is a lease? A lease is basically a contractual agreement between two persons, a lessor and a lessee, where a lessor passes his interest, to a lessee for a period, for a specified and a defined period of time, with exclusive possession. That is very important. With exclusive possession, with the provision of rent. Basically, that is what it means by a lease. A lease is a contractual agreement between two persons, a lessor and a lessee, wherein a lessor passes his interest to a lessor with exclusive possession for a given specific and specified or defined period of time with a provision of rent. That is very, very important. You need to know that a lease must specify period, must be certain in period. In short, you can't, someone can't can't say that I've leased your land, you'll be there for until drought maybe ends, because you don't know when drought will end. That is lack of uncertainty. There is an element of uncertainty in that lease. So the lease must specify time. The moment it does not specify time, then that does not amount to a lease, except maybe if except in a few circumstances, but a lease must be certain in time. And of course, when we are talking about leases, you have to first take you to the provisions of the Constitution, basically under Article 237, clause 2, paragraph C, where it provides that non-citizens can only acquire a leasehold in Uganda. Therefore, a non-Ugandan cannot acquire Milo, cannot acquire customary, cannot acquire freehold, but can only acquire a leasehold in Uganda. That is very important when we are dealing with leases. Also, the same thing is provided for when you read Section 41 of Land Act. It also provides that non-Ugandans can only acquire lease, and a lease that exceeds 5 years must be registered. And also, these non-Ugandans can only acquire a lease of not more than 99 years. That is very, very important. We need to know, how is a lease created? How do we create a lease? And creation of leases is provided for when you read the Land Act, Section 3, subsection 5. It provides that a lease can be created by an agreement or by operation of the law. That is very important. I repeat, a lease can be created by law or by operation of the it can be created by operation of the law or can be created by agreement pursuant to Section 3, subsection 5 of Land Act. That is very, very important. You take time and read that provision. Of course, I must remind you that in Uganda, land is held in several tenure systems, but for purposes of lease or of holding lease, of having a leasehold, you have to appreciate Article 237, clause 3, paragraph D. Paragraph D. Okay, that is very, very important that we need to appreciate. You need to know that as far as creation of leases is concerned, leases create what we call covenants. And these covenants bind on both parties, the lessor and the lessee, even bind on person that will inherit the title that is affected by such lease agreement. Because when actually that is the summary of what is provided for under section 101 of the Registration of Titles Act. Take time, read that provision. It will shed more light with respect to covenants that are established by uh, lease agreements. That is very, very important. Let's now look at classification of leases, different categories of leases, as we delve so much into the law of leases. We have what we call fixed term leases. We also have what we call periodic leases. We also have other minor. They look like minor, but they are also categories of leases. There's what we call tenant at will. There is also what we call tenant at sufferance. So let's now delve so deep into each of these categories. What is periodic? Actually, what is a fixed term lease? Let's begin with fixed term lease. A fixed term lease. This is a type of lease where parties to a lease agreement specify time within which that agreement will last, within which that agreement will take effect. That is very important. For example, here, it is basically looked at, for example, if parties enter into an agreement for a lease of, let's say, 99 years, that is 99 years fixed. If the 99 years exceed, then it will automatically terminate. It's like when you say the lease agreement will end for only 30 days. The lease agreement is only for 59 years. The lease agreement is only for 64 years. Years or period of time is fixed. You cannot now later on say, so it must be fixed. For you to create a fixed lease, years must be specified and marked, knowing that nothing can change the years fixed under that agreement. That is very, very important. And there is what we call periodic lease. Periodic lease is also a type of lease that continuously renews itself. It continuously renews itself. For example, this can be weekly, monthly, annually. That is what we mean by periodic lease. That for it, there is no need of coming back to sit and renew it. It automatically renews until the lessor terminates it. Of course, termination follows the procedure that must be followed during the termination process. So for it, it renews. It is weekly. It is monthly. That every after month, you end and begin, without the need of calling back the lessor and the lessee to sit on table and draft a new lease agreement. That is very important. And to that effect, you have to look at the case of Prudential Assurance Company Limited versus London Residuary. It's a case of 1992, volume 3, All England Law Reports at page 504. That case brings it out very well, what amounts to a periodic lease. And basically, the jurisprudence therein says that for one to terminate the lease, the periodic lease, then there must be service of notice. You must serve notice to the lessor alia in time prior. So you must give a notice to the lessor with respect to termination. So that is very important. Take time, read that case, the Prudential Assurance Company Limited versus London Residuary. It's a case of 1992, volume 3, All England Law Reports at page 504. That is very, very important. As I told you, we have other two categories of leases, or what we call other two categories of tenancies. And number one is called what we call tenant at will or tenancy at will. A tenant at will, this is a type of tenancy, or is a type of, let's say, a lease, where a person comes to the landlord's land without specification as to payment or as to period. Just someone comes on someone's land. Let's say, for example, if Peter goes to occupies John's land without specifying the period, without specifying how this person, whether or even whether this person will be paying rent, that's what we call tenant at will. And to that effect, you have to look at the case of Bweya Steel Works Limited versus a National Assurance Corporation. That case brings it out very well. It actually defines who is a tenant at will. It's a case of 1985 High Court Bulletin at page 500, at page 58. That case defines who is a tenant at will. It defines a tenant at will as that person who enters into possession of the landlord's premises. A person who enters the landlord's premises without specification or stipulation of the terms of the tenancy. That is very important. That means, look, I gave you an example. Peter entering John's land without specifying whether the period, without specifying the payment of rent. That's what we mean by a tenant at will. Then when you go to a tenant at sufferance, this is basically applies to persons. For example, if you have been renting a certain property, you have been in certain premises, but your tenancy ended. Let's say you had a tenancy of 40 years. When years end, when there is an expire of the specified period, for you, you remain in that house, in that land or on that property. Then during the period you are remaining there, you are regarded as a tenant at sufferance. And it is important to note that that type of tenancy can be terminated at any time without notice. That is very important. And if I may take you back to a tenant at will, if it happens and a tenant at will starts paying, let's say starts paying per month, then that changes from a tenant at will and becomes periodic, because you have started paying like monthly, or weekly. That is no longer a tenant at will. That now he or she has shifted to being a tenant at will to being periodic, under periodic lease. That is very, very important. And when you actually read the case of Hosanna versus Mushibi, it's a case of 1978 High Court Bulletin at page 162. It defines who is a tenant at sufferance. It defines who is a tenant at sufferance, and it provides that the jurisprudence says that a tenant at sufferance is implied where a former tenant remains in the rented house or premises when there is an expiration of the lease. That is what we mean. And you have to really, really appreciate that. So as I must emphasize this, that a tenant at sufferance, or what we call tenancy at sufferance, can be terminated at any point. In short, you are living in the premises of the landlord just at his own mercy. He can wake up one day, even he can wake up at night and says, no, you are not supposed to be here. Just do away with this. Because first of all, you need to know that he has not renewed your tenancy. That is important. He has not renewed your tenancy. And there is no law that says that a landlord must renew the tenancy. The renewing of tenants is at the mercy. Depends on how you have been dealing with the landlord, depending on how actually he benefits from his tenants. Those are the circumstances that can lead to him renewing the tenants. But there is no law that forces a landlord to renew. That is very, very important. But he can renew. I'm not saying that he cannot renew, but he can renew. So back to tenant at sufferance. the tenancy at sufferance can be terminated at any time without notice. In the next video, we are going to look at the essential elements. What is essential? What should be considered within the will, no, not will, but within the lease. What are the essential elements of a lease? Basically, we are going to look at certainty of period, certainty of time. We are also going to look at what we call exclusive possession, the doctrine or the principle of exclusive possession with respect to leases. Otherwise, thank you so much for now. Remember to subscribe. Remember to share with friends. Let's develop the art of learning together. Thank you. Thank you so much.